In 1996, a judge in Dallas, Texas asked the question, can the court system respond more effectively to domestic violence if all the cases are handled by judges and staff with specialized knowledge of family violence?
There was a judge, Marshall Gandy, who had this crazy idea that rather than deal out domestic violence cases as if they were, cards in a deck, that he invited all the judges to give him their domestic violence cases. What Judge Gandy brought to that designated court was an understanding of the issue. He brought bailiffs who knew how much danger that courtroom was in because they understood the issue of domestic violence.
In 2006, Judge Roberto Cañas took over the court, strengthening the court's ability to respond quickly to domestic violence in hopes of preventing future violence.
You see her every day to see the child?
Yeah, just
Okay.
my mom is there, and
Okay.
just never alone.
Okay. Well, you understand that that's not what the order says. It doesn't say you can see the child if your mom's there or so long as you're not alone with Miss Clark. It just says you can't talk to her, you can't be around her, you can't see her, okay? There's no exception for that, even though you have a child together.
Yes, sir.
All right? We handle domestic violence cases 5 days a week, all day, and that's all we handle. At any given time, we have about 12 to 1,300 active cases. The goals of the domestic violence court fundamentally are offender accountability and victim safety. I mean, everything we do connects back to those two ideas.
This is the understanding that Judge Cañas has, that this is not just a misdemeanor case, that how he determines this case can make a difference as to whether or not it ever becomes a felony, that it ever becomes serious bodily injury or perhaps a homicide.
One time every week.
Recognizing the court as a national leader, the Federal Office on Violence Against Women selected Dallas County Criminal Court No. 10 as a domestic violence mentor court. The court's response to domestic violence begins from the moment it receives a case with a special focus on victim safety.
I had been in a 5.5-year abusive relationship with my son's father. I left him in January of 2013. The text messages that he sent me were horrific. And in May of 2014, I found a tracking device on my car. My concerns were first and foremost the safety of me and my children. The ADA that was handling the case saw the connection between former intimate partners. And she was like, this doesn't belong in just a normal court. It belongs in family violence court because it's a crime against a child mother.
The very first time they were ordered to come to court, that's when we normally take care of addressing any safety concerns that have come up.
Because domestic violence is not about a fight that got out of control, that it's all about power and control. We know that that courtroom is possibly the most dangerous place she could be. It may be the first time he sees her since she left in the night with her children and a bag full of clothes.
We spend a lot more time on the phone with people than they do in other courts because we have got to call every single victim to determine whether or not there are safety concerns, ask if this has happened before. Additionally, we work really closely with our victim advocates who are also in this building.
While advocates accompany victims to court and link them with services such as shelter and counseling, the court further enhances safety by providing a separate waiting room for victims.
It was very terrifying to go and sit on a stand and tell my story again to somebody and try to get them to understand and have empathy, and it was hard. But the family violence court, the victim advocates, the ADAs that work in that court always made me feel that my children and I were important.
The court works with community-based providers like Genesis Women's Shelter to promote victim safety around the clock. The shelter provided Ruth and her children with a safe apartment in a secret location and sent volunteers to support her in court.
We have an auxiliary that is, we call them our heroes, and it's He Respects Others. It's a men's auxiliary made up of gentlemen who say, it's not okay in my house, and it's not okay with me if it's in your house. They might mentor our boys, they may take them to the cowboy games, but one of the things they do is literally go and sit in court, and they're sitting in there in their suits and their ties. All of a sudden, Again, the judge is paying attention, the bailiff's paying attention, people are on their toes, and I gotta tell you, it makes a difference.
The court gallery was filled with those people to support me, and that made me feel good to know that there are other people out there that actually know what we go through and want us to know that they're there to support us.
The court rigorously monitors compliance with orders of protection and often requires defendants, as part of their sentences, to participate in a batterer's intervention program.
The traditional program will serve the individual for 24 weeks. It's a minimum, and so it is a group process, and a minimum of 15 clients are participating through the group process. For the high-risk offender, it's a smaller group size. The program has been extended to 30 weeks. The individual is also monitored through the court system on a weekly basis.
So open communication, so tell me more about that. What does that look like? You talking, she listening, or both of you guys?
When I first decided to run for this court, I decided to attend the Batterers Intervention and Prevention Program, the entire course from beginning to end. It was valuable experience for me to see the progress that men can make in that group and where they start off. I saw guys who were basically in tears, because of the things that they had learned. It finally had hit them, the effect of the violence that they had been perpetrating on their intimate partner.
Those who come to the program from the court system, they're more likely to complete the program. They're more likely to see consequences if they don't complete the program.
I catch myself in a situation.
I was in an altercation involving one of my girlfriends and one of my exes as well. And subsequently, I was charged with family violence. It was a Class A misdemeanor, and also unlawfully carrying a weapon. Because I had my weapon on me at the time, I ended up being put on probation. At first, I had to report every week, but now I have to report every 2 weeks. Me being close to ending the probation, I have to take UAs, which are drug tests. I had to attend a BIP class. BIP is Batterers Intervention, Prevention, that's what it is. And I completed all 24 classes, like about 2 weeks ago. One of the conditions that really stuck with me was the condition to where you can't talk to the victim or contact them in any type of way. And if you did, you would end up back in jail.
Defendants return to court on a regular basis to provide updates on their progress.
When I first took the bench, I was just seeing so many cases where I had a guy who was on bond. He would pick up or commit or be accused of another assault family violence case. And I was not finding out about it until 6-7 weeks later. And that was just completely unacceptable, and I wanted to flip that dynamic. Then we also started the high-risk offender probation docket, and this is guys who are high risk at recidivating, maybe going out against the same victim or a new victim.
On a conventional caseload, we would see the individuals once a month. On a high-risk caseload, we see them on a weekly basis. Some of the sanctions are judicial tongue lashing, where he admonishes them to be compliant in the class, and if they are not compliant in the future, then there are further consequences, jail time, or have us to file a motion to revoke their probation term.
We'll have the judge talk to them directly, and when he talks to them, it's very clear what he expects from them, what they're supposed to be doing, what they're not supposed to be doing.
I asked your lawyer to bring you in so that way you and I could have a short conversation. I got a report dated January the 10th, and it says that you've attended 2 classes. In the month that you've been enrolled there, you've attended 2, but you've missed 2. If you don't complete the classes, then basically what you're telling me is you don't want to be in control of your own destiny. You want me to make a decision about it, or you want 6 people who you've never met sit in a jury box and make a decision about your life, or the prosecutors, or somebody else other than yourself, okay? Okay. All right.
In 2013, Judge Cañas implemented protocols to ensure offenders surrendered their firearms, as required by both state and federal statutes.
The way our process works is that if I, as a judge, order an offender to dispossess himself of a gun, the sheriff's office will accept the gun, store it for as long as they need to store it, and return it if necessary. If the offender can never get the gun back, then the sheriff's office will destroy the firearm.
When someone's charged with a family violence offense, it's important to talk about not only the offense itself, but all the things that can follow that. And one of the things that Judge Cañas is keenly concerned about, as he probably should be, is access to firearms. And that's something that I talk to my clients about a lot, is firearms and the implications about that.
Judge Cañas explained to me that having a gun, after I've been charged with this, can land me back in jail, like at any time, even after this case is over with or after I'm done with probation, I still can't own a gun.
As a domestic violence mentor court, Dallas County Criminal Court Number 10 provides guidance and training to other jurisdictions seeking to strengthen the judicial response to family violence.
It's taken 30 years to even get to the point where we're at, to even have a special court that has an understanding and is educated on what domestic violence looks like, because it doesn't look like any other crime. It looks so much different, and having a judge understand that means the world to me. And I know it means the world to the other people who have gone through his court.